Are following up on a brewing controversy over the arrests of more than 20 accused members of the Lake Boys gang in Fort Myers. Last month, authorities arrested them using a law known as the Rico statute. It's designed to crack down on organized crime. Well, the NAACP is now questioning some of the charges, specifically the racketeering charge. And new tonight, 4 in Your Corner's Tony Sadiku taking this debate to some legal experts, not directly associated with the case, but to get you some perspective. Tony?
Patrick, legal experts telling me this is going to be a complicated case going forward. But while some praise FMPD for using the RICO Act to get the gangs off the streets, others are critical, saying the blanket charges may be going too far.
It's scary.
Scary. That's what attorney Scott Goldberg says the RICO statute means for the more than 24 accused members of the Lake Boys gang.
The scary part for the individuals that are in jail is they're being charged with a crime they've never heard of before. Their bond is $1 million.
And as former state attorney Joe D'Alessandro explained to me, a conviction under the RICO statute could mean 20 years in prison for those now facing racketeering charges.
It's for a broad act that's got a lot of players in it. And individually, you couldn't get every one of them on their own, but by throwing out the net, you can get a whole lot of them.
It's a very big hammer for the federal government.
Goldberg is representing the NAACP as some of the arrestees' families turn to the group.
I don't think anybody has seen enough information to make a determination of whether it's being abused or not abused in this situation.
But Lee County NAACP President James Muwakil already raising questions that the sweep may be too extreme.
No African American in their reasonable mind believes that all 20-something of those young men are guilty of racketeering. Some maybe.
D'Alessandro says the ultimate burden of proof falls on the state, but tells me he thinks applying the RICO statute in this case is a good move.
I think for the community it's a good move. Law enforcement's trying to be proactive, not reactive.
And the Lee County NAACP will be holding a community meeting tomorrow night where Goldberg will be explaining to the public where RICO is and how it might be being used in this case. Live in the studio, Tony Sadiku, Fox 4 in your corner.
Okay, thank you, Tony. We want you to be part of this community conversation. Do you think racketeering charges against these young suspects is the way to go? Tell us why or why not. 239-206-FOX4 or email news@Fox4Now. And we're going to be sharing some of your views straight ahead at 6:30.
The RICO Act, Racketeer Influenced and Corrupt Organizations Act. The Racketeer Influenced and Corrupt Organizations Act, commonly referred to as the RICO Act or simply RICO, is a United States federal law that provides for extended criminal penalties and a civil cause of action for acts performed as part of an ongoing criminal organization. The RICO Act focuses specifically on racketeering, and it allows the leaders of a syndicate to be tried for the crimes which they ordered others to do or assisted them in doing, closing a perceived loophole that allowed a person who instructed someone else to, for example, murder, to be exempt from the trial, because he did not actually commit the crime personally. 1. RICO was enacted by Section 901A of the Organized Crime Control Act of 1970, PUB.L. 91-452, 84 Stat. 922, enacted October 15, 1970, and is codified at 18 Us. CCH. 96 as 18 Us. See paragraph 1961 to 1968. G. Robert Blakey, an advisor to the United States Senate Government Operations Committee, drafted the law under the close supervision of the committee's chairman, Senator John Little McClellan. It was enacted as Title IX of the Organized Crime Control Act of 1970, and signed into law by Richard M. Nixon. While its original use in the 1970s was to prosecute the mafia as well as others who were actively engaged in organized crime, its later application has been more widespread. Beginning in 1972, 33 states adopted state RICO laws to be able to prosecute similar conduct. Summary: edit. Under RICO, a person who has committed at least 2 acts of racketeering activity drawn from a list of 35 crimes, 27 federal crimes and 8 state crimes, within a 10-year period can be charged with racketeering if such acts are related in one of 4 specified ways to an enterprise. Citation needed. Those found guilty of racketeering can be fined up to $25,000 and sentenced to 20 years in prison per racketeering count. Citation needed. In addition, the racketeer must forfeit all ill-gotten gains and interest in any business gained through a pattern of racketeering activity. Citation needed. When the U.S. attorney decides to indict someone under RICO, he or she has the option of seeking a pre-trial restraining order or injunction to temporarily seize the defendant's assets and prevent the transfer of potentially forfeitable property, as well as require the defendant to put up a performance bond. This provision was placed in the law because the owners of mafia-related shell corporations often absconded with the assets. An injunction and/or performance bond ensures that there is something to seize in the event of a guilty verdict. In many cases, the threat of a RICO indictment can force defendants to plead guilty to lesser charges, in part because the seizure of assets would make it difficult to pay a defense attorney. Despite its harsh provisions, a RICO-related charge is considered easy to prove in court, as it focuses on patterns of behavior as opposed to criminal acts. 2. RICO also permits a private individual damaged in his business or property by a racketeer to file a civil suit. The plaintiff must prove the existence of an enterprise. The defendants are not the enterprise. In other words, the defendants and the enterprise are not one and the same. 3. There must be one of 4 specified relationships between the defendants and the enterprise. Either the defendants invested the proceeds of the pattern of racketeering activity into the enterprise, 18 Us. See paragraph 1962a, or the defendants acquired or maintained an interest in, or control of, the enterprise through the pattern of racketeering activity, subsection b, or the defendants conducted or participated in the affairs of the enterprise through the pattern of racketeering activity, subsection c, or the defendants conspired to do one of the above, subsection d. 4. In essence, the enterprise is either the prize, instrument, victim, or perpetrator of the racketeers. 5. A civil RICO action can be filed in state or federal court. 6. Both the criminal and civil components allow the recovery of treble damages in triple the amount of actual/compensatory damages. Although its primary intent was to deal with organized crime, Blakey said that Congress never intended it to merely apply to the mob. He once told Time, "We don't want one set of rules for people whose collars are blue or whose names end in vowels, and another set for those whose collars are white and have Ivy League diplomas." 2. Initially, prosecutors were skeptical of using RICO, mainly because it was unproven. However, during the 1980s and 1990s, federal prosecutors used the law to bring charges against several mafia figures. The first major success was the Mafia Commission trial, which resulted in several top leaders of New York City's 5 families getting what amounted to life sentences. By the turn of the century, RICO cases resulted in virtually all of the top leaders of the New York Mafia being sent to prison. State laws, edit, beginning in 1972, 33 states, as well as Puerto Rico and the U.S. Virgin Islands, adopted state RICO laws to cover additional state offenses under a similar scheme. 7. RICO predicate offenses, edit, under the law, the meaning of racketeering activity is set out at 18 Us. See paragraph 1961. As currently amended, it includes any violation of state statutes against gambling, murder, kidnapping, extortion, arson, robbery, bribery, dealing in obscene matter, or dealing in a controlled substance or listed chemical as defined in the Controlled Substances Act. Any act of bribery, counterfeiting, theft, embezzlement, fraud, dealing in obscene matter, obstruction of justice, slavery, racketeering, gambling, money laundering, commission of murder for hire, and many other offenses covered under the Federal Criminal Code, Title 18. Embezzlement of union funds, bankruptcy fraud or securities fraud, drug trafficking, Long-term and elaborate drug networks can also be prosecuted using the Continuing Criminal Enterprise Statute. Criminal copyright infringement, money laundering and related offenses, bringing in, aiding or assisting aliens in illegally entering the country if the action was for financial gain, acts of terrorism. Pattern of racketeering activity requires at least 2 acts of racketeering activity, one of which occurred after the effective date of this chapter and the last of which occurred within 10 years, excluding any period of imprisonment after the commission of a prior act of racketeering activity. The U.S. Supreme Court has instructed federal courts to follow the continuity plus relationship test in order to determine whether the facts of a specific case give rise to an established pattern. Predicate acts are related if they have the same or similar purposes, results, participants, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics and are not isolated events. H.J. Incorporated v. Northwestern Bell Telephone Company. Continuity is both a closed and open-ended concept, referring to either a closed period of conduct, or to past conduct that by its nature projects into the future with a threat of repetition.